Good afternoon. Some of you have seen me this morning. Just to repeat, my name is Sonja Boelaert. I'm a senior legal advisor with the Council of the European Union, but we also the legal service for the European Council. That said, I am not here in an official capacity. I was asked to contribute to this workshop because I'm one of the main agents for the EU-Turkey statement litigation, which is a point of interest this afternoon. I would like to, in the very little time we have, deal with three subjects. First of all, I will say a few words on competence in the area of asylum and migration. Then I will highlight some of the main points of the contested orders of the General Court as I see them. And then I will tackle the interesting question put to us by the convener. Now, for the basic competence analysis, what Paula said is right. The area of freedom, security, and justice is basically shared competence as set out in primary law. The exercise of competence is subject to principles of subsidiarity and proportionality, and ERTA principles apply. There is one major exception in the area of migration and asylum, is that the European Union has no competence, as also Paula said correctly, to deal with volumes of admission. Then there is also another small carve-out. The European Union has no competence to deal with integration measures, but that's not relevant for our discussion this afternoon. It's interesting when you talk about competence and external competence, is that the European Union has in the past not been very insisting on exercising exclusive competence. When you look at the readmission agreements, most of them have been concluded as, all of them have been, I think, concluded as exclusive competence agreements. An important point to remember when you talk about competences in general is that under the treaties, there are possibilities for the member states to take back competences. There's an Article 2.2 that says that the European Union can cease to exercise competence, and then the competence reverts back to the member states. Also, in areas of exclusive competence, the European Union can empower the member states to act, and I will come back to this point later on. Now, what can I say about the EU-Turkey statement litigation? The first point I need to say is that the cases are on appeal. They're sub judice. I can only talk about issues which are in the public domain. The orders are public. There's also a confidential version. Now, I would like to highlight some of the main points because I think it is important, especially for lawyers, to read the orders carefully. And at times, I think the discussion in the public domain doesn't really follow what the General Court has done. So on the 20th of February 2017, the General Court dismissed by orders the actions for annulment brought by 3 applicants who, at the time they lodged the application, stated they remained in Greece, on the islands or on the mainland. They also claimed that they fell within the scope of the EU-Turkey statement. An important point to note from the outset is that the sole defendant in the case, as framed by the applicants, was the European Council. Nonetheless, the General Court performed an in-depth analysis using all the tools available to it under the rules of procedure to ask questions and full documentation from other institutions, which is unusual. But the other institutions that were interrogated, at least in writing, by the General Court were the Council of the European Union and the Commission. In its orders, as we all know, the General Court holds that it lacks jurisdiction on the grounds that the EU-Turkey statement, which was published by means of a press release, cannot be regarded as reflecting a measure by the European Council, or moreover by any other EU institution, body or agency. In dismissing the actions, the General Court closely followed one of the pleas of inadmissibility or lack of jurisdiction that the European Council, as main defendant, leveled against the application. But there were other grounds of admissibility which the General Court did not take up. The General Court concludes that from all the explanations and all the documentation that was provided to it by the European Council, the Council of the European Union and the Commission, that European Council as an institution did not adopt a decision to conclude an agreement with Turkey in the name of the European Union, and that it did also not commit European Union within the meaning of Article 218. It's also important to note that the General Court accepted that the meeting of the 18th of March of 2016, at the end of which the EU-Turkey statement was issued, was not a meeting of the European Council, but it was a meeting of the member states. More precisely, heads of state or government on the one hand, meeting with their Turkish counterpart on the other. A next point I want to highlight is that the court did not pronounce on whether, as European Council maintained, the EU-Turkey statement was a political statement, or whether, on the contrary, as the applicant submitted, that it was a measure capable of producing legal effects. The court does not decide either whether or not the EU-Turkey statement amounts to an international agreement concluded between the member states and Turkey. But the court did note that even if it were to be the case, that the court has no jurisdiction over measures or international agreements concluded by member states. So, before going to the next point of my brief contribution, in our view, the European Council's point of view, the General Court did generally examine whether or not the European Council could be considered the real author of the EU-Turkey statement. The court said it very explicitly in its orders. It understood what the claims were made by the EU institutions, but it went behind these claims. It did perform an in-depth analysis of whether or not, in spite of the claims made by the institutions, that whether or not the EU-Turkey statement could be regarded as a measure taken by the EU institutions, and it decided it was not the case. Now, the question that the convener has put to us is an interesting one. Did the General Court miss an important point? Did the General Court miss the point that, in fact, the subject matters referred to in the statement are subject matters on which member states can no longer act? I do not wish to pronounce on whether or not the legal analysis is right, but let's assume for the sake of argument that the subject matters of the EU-Turkey statement are subject matters that no longer fall within the competence of the member states, that the subject matters fall entirely following an errata analysis under the exclusive competence of the European Union. Once again, I haven't done the analysis and I don't want to pronounce myself on that one. Let us assume that the General Court is right, that the European Union did not author the EU-Turkey statement. And let us also assume, a point that the General Court did not decide, that the EU-Turkey statement reflects a series of measures taken by member states. Is it permissible for the EU not to exercise the exclusive competence that it has? Is it permissible for member states to fill this void? And is it permissible for such member states to escape judicial review by the Court of Justice? I propose to try to answer this question by dealing with two hypotheses. The first hypothesis is that the EU has taken a decision allowing member states to act in an area of exclusive competence. As I mentioned before, it is possible for the European Union to sort of hand its powers back to the member states. And there is very old case law, a case from the 1990s, case 174/94, bulk oil, which actually says that this can happen and that the bar for this is very low. I am very skeptical that this low bar would still hold after the Lisbon Treaty because, first of all, we're not in an area where the Council can act on its own. We also would need the agreement or the consent of the European Parliament before the Union can hand a power back to the Member States. But regardless, in my view, the decision of the European Union to hand power back to the Member States is a political decision. A political decision that falls within the discretionary powers of the EU's institution. I know in this case there's no indication whatsoever that the European Union would have taken a decision handing its powers back to the Member States, but assuming that it had, what could we do with this? Can this be contested? Now, the only points of contestation that the Court of Justice could deal with would be procedural issues. Has the decision been taken on the correct legal basis? Has the European Parliament given its say, etc., etc.? There wouldn't be no possibility for the Court of Justice to review the merits, the political decision to hand powers back to the Member States. So this hypothesis doesn't lead to anything useful. The second hypothesis is also an interesting one. Suppose the EU has not taken a decision allowing member states to act in an area of exclusive competence. I'm still proceeding on the assumption that there is indeed an argument to say that the subject matter of the EU-Turkey statement falls under exclusive competence only by hypothesis. What would be then the analysis? Well, the EU has failed to act. It has illegally allowed the EU member states to take up the baton. What can be done about this? Firstly, you would say, well, the European Commission should bring an infringement proceeding against the member states who have acted illegally in an area of exclusive competence. The problem with that argument is that, once again, the European Commission has discretion whether or not to bring infringement proceedings. So that is not a useful avenue. Can we conceive of a direct action being brought against EU institutions because they let member states act illegally in a domain of EU exclusive competence? The question which I have is, what institutions would you sue? The European Commission for not bringing forward an infringement action? The Council possibly for not requesting or suggesting that the European Commission should start infringement proceedings? Even if you could think of such an action to be brought successfully, you will always stumble on the issue of discretion. One could also think maybe we could start thinking of an action for failure to act under Article 265 of the Treaty of the Function of the European Union. But the conditions for a successful action for failure to act are very strict. You would have to prove that there is a duty to act. You would need to identify the measure that would have to be taken, and you need to be in the correct position. If you're not an institutional actor, if you're not a member state or a European Union institution, European Parliament, you're in the situation of an individual litigant, and an individual litigant would have to make clear to the court that the European institutions illegally fail to act by not taking a decision vis-à-vis the litigant. And that is something that will lead to nowhere. And I have a case that illustrates this very clear. It's a case that I also mentioned this morning, the Mughrabi case, where a Lebanese citizen brought in action, amongst others, for failure to act against the European Council and against the Council of the European Union and the Commission, for not suspending the association agreement with Lebanon, whereas the claimant said that he had proved that his human rights were being violated by Lebanon. There was also a human rights clause in the association agreement, and the claimant claimed that the European Union should have suspended the association agreement with Lebanon to enact pressure on Lebanon. The case was dismissed. So, in my view, even if an argument could be made that the EU-Turkey statement should have been concluded as an international agreement properly following the procedures by the European Union, this is not an issue that the General Court can deal with. So I think that's all I can say on the EU-Turkey statement. Now, as regards the UN Global Compact, I'm sure my time has run out by now. There's also very little I can say on this one, since these issues are currently being discussed. But I would like to stress that in our internal EU practice, we make a very clear distinction between decision-making, internal decision-making on the one hand, and external representation on the other hand. To be very clear, the Commission needs to get the approval from the Council, regardless of whether the document is legally binding or not. For us, the decision-making procedures do not change depending on the legal nature of the document. What may change is the internal procedure, and we have a recent case where the Court of Justice made clear that a memorandum of understanding, which was a non-legally binding document, could not follow the procedure set out in the treaties for concluding international agreements, but the Court did make clear that it was not permissible for the European Commission to go off and sign a memorandum of understanding just because it was non-legally binding. The case in question is the Swiss MOU case, case 660 of 2013, and judgment of the Court of Justice Grand Chamber of the 28th of July 2016. Thank you very much for your attention.